Right now he's handing out a study guide, and as our presentation continues, you will have the opportunity to fill out key information. And the number will be for the review game at the end, and it's also a sticker that is a Columbus State University. So up here we have the First Amendment and the 14th Amendment, and this is the blueprint for freedom of expression and religious liberty. So Monica is going to pass out two situations, and we want you to apply your knowledge of the two amendments to support whether or not you would be for the student in this situation or whether you would be for the teacher, and which elements would you bring to court to support you. Yes. Right now.
Here you go. Come with. Pass it back.
All right, let's go ahead and get started. With anybody for the scenario 1 would like to give reasons that would support students in that type of situation based on these two amendments, the first and the 14th.
Or just reasons, I guess. We can start there. Reasons for the students wearing the shirts or
To
the rest
justify
of the
it.
student body? Both. We can start with the student.
Well, I'd say in the first scenario, depending on what the school dress code was, if they had issued anything that was like you can't have a politically based shirt, I guess then maybe they could, but if there was nothing that was specifically pertaining to this topic, I think the student should be okay to wear it.
Okay. Or would it be considered gang-related type paraphernalia also? So I don't know. It depends. It could go either way.
It could go either way, but they're not a gang. They're just wearing
No, I
matching
agree.
shirts. Like school teams wear matching
Or
shirts.
like sororities.
Sororities matching shirts.
I agree. I guess it just depends on how you want to look at it.
Well, I know with bullying stuff, I'm not really part of bullying, but I'm just saying, with bullying cases we did in the First Amendment, they were justified in getting in trouble if it disrupted the school day somehow. So if it bothered people enough to where it actually caused a disruption or caused a change in school, as in like grade, something like that, then it's a disruption more than the First Amendment.
Right.
I don't know if that's correct.
That's a very, we're going to see that in a lot of our cases. So it's interesting that, I guess we want you to see from how opinions can develop from the amendments themselves, the situation, and we'll see in the cases what people and what the lawyers and attorneys use in court to justify whatever their expression is. So situation 2.
I have a question.
Yes.
How did they refuse to participate?
Basically, they refused by not participating in the speech.
Oh, gotcha.
Was it something like each student had a line?
Or was it like everybody together recited it and they just chose not to say it? Does that make sense? Like, were
Everybody
they-
had a line, everybody
Okay.
had a part.
I think everybody has the right to their own opinion. I mean,
Let's say if you don't necessarily have to say the Pledge of Allegiance.
right, so why
So-
should they have to say that? I mean, I think everybody
But
has,
the church, the same reason for not wearing the versionary, but it's prompt, it's message, you know, management, causes disruption.
Yeah.
I think that.
I think the shirt's an
a
issue.
Confederate flag
They're
shirt would
refusing to
cause a lot more
participate.
disruption.
But they could not, I mean, whoever did, you know, gave them the card and all, if they didn't want to do it, it seemed like they would have known at the beginning. They should, you can refuse in the beginning and say that I don't want to take part in it, I don't want to say it. Then it would have kind of handed them the day of the speech to protest it in a way, you know, where their Confederate shirts and then they refused.
but could it have been something that the teachers kind of coerced the students to, well, hey, you have to do this, you're getting a grade for it.
Did the
You
kids
know what I
get
mean?
in
Like, do
trouble?
they have to do it?
In scenario 2, try to look at the situation as Martin Luther King's birthday and they refuse, and as, I guess, to boycott it, they wore Confederate flag shirts. Could the students say, oh, I was just expressing myself?
I would think, I mean, like, if they wore the shirts on a different day, would that have caused a disruption? And if not, well, I would say if not, then then it's hard to say that they caused a disruption that day. Because of the circumstances they did, but if it's not a problem on a regular day, I wouldn't think it would be a problem on a non-regular day, but I don't know if they wore it prior to that. It may have just been that day they chose to wear it, now that may be a problem.
Or if it was like a
If it's
handmade
something they
shirt.
wear,
They made it.
Yeah, if it was a handmade shirt, I think I would definitely have a problem with it.
yeah.
Yeah.
Well, your thoughts you'll see them in our cases, so.
Will we write though?
Yes.
Alright, so, 14th Amendment?
No, only thing I want to say about this, because as you'll see in some of the cases that we have, I underline some of the key things that when the courts were going through and deciding some of the cases, some of the things that they looked at in pertaining to the 14th Amendment was the due process part of the 14th Amendment and also the equal protection of the law portion of that amendment. So that is one thing, that's one of the reasons why I underlined it, because you will see that in a couple of the cases that I'm going to do, and that mainly pertains to those particular amendments and that portion of the amendment, dealing with protection, equal protection and due process.
So we've seen, we kind of have a little timeline for you guys to see just how, with the times, the dress codes have changed. In the 1950s, most women were required to wear skirts and of various lengths, and they were prohibited from wearing slacks. In the 1960s, your typical greased attire was becoming popular. In the 1970s, and we'll see this later, that there were a lot of cases that had to do with how men groomed their facial and their hair.
Can I say something about this? And you'll see in the 60s, in the 70s, there was a lot of the things that went on with the grooming in there was because of the change of the time during the 70s. Everybody know what was going on during the 70s? Vietnam War, peace, hippies, and different things like that was going in that time frame. And it was coming from the clean-cut 60s into the more free, liberal 70s. And a lot of that transitioned into not only into the regular life, but also into the schools and stuff like that.
In the 1980s, we started seeing more gang dress in the schools, and school uniforms were suggested in response. In 1996, President Clinton endorsed the idea of public school uniforms, and now in the 2000s, we see things like flip-flops, low-cut shirts, too high, too small of shirts, short shorts, mini skirts, baggy jeans. So the big question in a lot of these cases, the court has to decide whether the student's speech is going to weigh more or whether the rights of the other students to be secure and to be let alone weighs more, like you were talking about. And taking into account that the authority of school officials is to maintain the discipline and learning environment necessary to accomplish the school's learning environment. So this is going to be really important when the defendant or the school is trying to defend themselves, because that is what they're supposed to be doing, upholding a positive learning environment. And sometimes dress can that. So Bruce was talking about the 1970s, and I have a short video to just put you into the context of the 1970s. The landmark case for student dress code took place in the 1970s, and it was intertwined with the controversy of the Vietnam War.
Rallies and demonstrations. Central Park is the starting point for the parade to the UN building. The estimated 125,000 Manhattan marchers include students, housewives, beatnik poets, doctors, businessmen, teachers, priests, and nuns. Makeup and costumes were bizarre. Before the parade, mass draft card burning was urged. Demonstrators claimed 200 cards were burned, but no accurate count could be determined. Reporters and onlookers were jostled away on purpose. Although mostly peaceful, shouted confrontations were frequent and fiery during the course of the march. The anti-war marchers were picketed by anti-war marchers who were hawkish toward the parading doves. Civil rights leader Martin Luther King leads the procession to the United Nations, where he urges UN pressure to force the U.S. to stop bombing North Vietnam. Police arrested 5 persons as disorderly. 3 were grabbed when they rushed the parade float. No serious injuries, however, in New York's biggest anti-war march. A companion peace demonstration brings out 50,000 marchers in downtown San Francisco. They parade 2 miles along Market Street, pacifist.
And as I was looking up things about the Vietnam War, I realized that there were many, many protests. So this was quite a big deal. So the schools anticipated that this controversy in the United States could kind of arise in the school, maybe students protesting, and so they went ahead and they made a dress code policy. And during that time, people would wear black armbands that would signify a mourning for those that were fallen in the Vietnam War. And so in the policy, a bunch of the schools got together, they said that the armbands could not be worn. So John, Mary Beth, and Chris decided to wear their black armbands to school. And as part of the policy, they were suspended. Now, their behavior when they wore the armbands was very peaceful. They didn't call attention to themselves. They didn't speak out loud about the armband. They simply wore it to school. And the teachers testified in court that it didn't cause a disruption in the class. And other students talked about it during lunch, but that's a safe place to have discussions. So in court, the plaintiffs claim that the First Amendment rights should be applied the same outside of school as within the school. And the policy that they made prohibited dress that would disrupt. And from the description that I told, this is Mary and their brother and sister. So do you think, according to what I was telling you about their behavior, So he went to the principal early the day that he wore it, and he said, I know that I'm wearing it, and I'm not going to take it off. So he asked me, he said, well, I have to ask you to take it off. And he said that he wouldn't. So by them wearing these armbands, do you think that this conduct materially and substantially interfered with the requirements of appropriate discipline in school?
Was the policy that you couldn't wear an armband, or the policy that you couldn't have clothing that would disrupt?
Both.
They couldn't wear the armband.
Yeah.
And so that's what they brought up in court. Well, why do I have to take off something if I'm not disrupting? I'm just voicing my opinion. I didn't
But
disrupt.
black armbands were specifically named.
Right.
Yeah, but
Right,
if it was something else, like they did, and something, but it was the black armband that they said they couldn't bring it.
Right. In this particular case, what happened was the principal got wind because they were talking about doing this because it was done during the Christmas time, and they were protesting. It was like a silent protest petition against the Vietnam War. So they wanted to show this solidarity for the soldiers and stuff. So they figured that, okay, in protest of this, we're going to wear this. The principal of the school got wind of this, so he thought because of them doing this, it was going to cause all kinds of things within the school. So he made the policy up so that that couldn't be done. And if anyone was caught wearing this, they would be suspended. And then they knew prior to coming to school, because of the policy, that by doing this, they were going to get suspended, but they decided to wear it anyway. Even though when they wore it, they didn't, there was no disruption, they was quiet and peaceful about it. They came to class and conducted themselves as normal and no disruptions whatsoever. But because of what the policy that the principal had placed ahead prior to, they were violating the policy. And their justification was that I have a freedom to express myself, and this is my way of expressing my displeasure with what's going on politically. So we didn't do any harm, we didn't cause any disruption within the class, so why couldn't we do this?
And it's interesting because many of you have the viewpoint that I had going into this. Well, if the policy says it, that's enough justification to, allow the school to be able to enforce that. But we're going to see that that's not necessarily the case in this case. Another important thing, in regard to dress code, this is a type of expression. So this is often addressed in court along with freedom of speech. So when it got to the district court, they upheld the ruling in favor of the school. They had a summary judgment. So they looked at the evidence to support that the efforts to prevent disturbance of school discipline were reasonable. So they supported them. But when the Supreme Court reviewed it, they showed that the students did not disrupt the school in any way. So the Supreme Court ordered in favor of the students, and they said that the school can't make a policy just to avoid controversy. They have to be trying to protect the learning environment, or trying to keep them from engaging in conduct that would interfere with the operation of the school. So they had to prove that by not wearing the armband, that would better make the school learning environment. And because there wasn't a disruption, there was no case. Now, it was interesting in the review, the judge asked them, well, what if the student would have got up in front of the class and said, yeah, I'm, anything. If he would have said anything, this case would have been thrown out. It's only because they didn't say anything about it.
Can I add one thing?
Yes.
To say what you said in another way, perhaps. She was making the point earlier that we seem to be focusing on, did they violate the policy? School was also focusing on, did the policy violate the student's constitutional rights, freedom of expression? And if you're going to violate the student's constitutional right there, you've got to have a very good reason to do it. A good reason would be if it disrupts the school environment. It didn't do it. It didn't cause a disruption, so that's why it became.
My only question would be, it very well could have had more students participated and there been more students, but because there are only the 4, like, I mean, I see where the school is coming from of, this could be a huge problem. If a lot of kids wear this, this could cause a big issue. But then with only the 4, I mean, I guess I see both sides of it. It's kind of,
And it will, actually.
it could cause a huge issue.
Right.
And I will also mention that I taught in a school during this time period in which students also wore the black armbands. And there was nothing other than the wearing of the armbands as a sign of protest in that environment also, and there were more than 3.
So it was just the school.
Pardon?
So it was just the school that was making it a problem.
It's not an issue unless somebody brings a suit about it, or it causes.
Unless they made a big
Right,
deal.
and that's the exact, I guess, this is why this case is a precedent case, because so many will refer back to this, okay, well, did it disrupt?
Yeah, it's not this one, the Tinker case.
Right.
You'll find it all over the place.
The next case that we have was Dunham versus Pulsifer. This case happened in Vermont in 1970. There was a student, 3 students who were on the Rutland Borough Union High School tennis team, and they were suspended from the tennis team for failure to comply with paragraph 2 of the school's athletic grooming code, which paragraph 2 of the grooming code state that all student athletes, male student athletes, will have their hair cut, not coming above the ears, and be tapered in the back, and present a neat appearance. These 3 students that was on the tennis team, their hair was quite longer than that, and they violated the policy. The plaintiffs was Dunbar, Smith, and Dunham, Smith, and Weber. They filed allegations that enforcement of this paragraph 2 of the athletic grooming code deprived them of their 4th Amendment right, equal protection of the law. Now, one of the reasons why they claim that is that the athletic teams were the only teams in the school that presented extracurricular activity that had a grooming code. There was other teams like the debate team, the band, other teams that were going out representing the school, but they didn't have a grooming code, only the athletic teams. The defendant was Pulser. He was the school superintendent, and he was the one who initiated the policy. And the defendant stated that the policy was to instill uniformity and conformity, which was needed to maintain an athletic program. That was one of the reasons he justified having that the policy. When they went to court, the court decided that the defendant presented no credible evidence that long hair on an athletic team of any cause would cause dissension amongst the team, and that was one of the other things he said, that long hair would cause dissension, and they would try to keep camaraderie within the team. And another thing that they said, while conformity was a reason for a rule, that conformity and uniformity within itself was not a reason for them to have such a rule, and they voted in favor of the plaintiff. Can anybody see why that they would rule in favor of the plaintiffs on that? Yes, no, any questions?
They wanted to be able to wear their hair longer than shortcut. They played tennis.
If it doesn't affect how they play and it doesn't affect anything else, then why should they have to cut it?
Right, but at this time, it was just going from the 60s to the 70s, and a lot of the schools, they had grooming policies that males would keep their hair cut short, be clean shaven, and stuff like that. And they claimed that, like I said, the school claimed that it was for uniformity and conformity, and also that it would help dissension. But during the trial, other members and even some of the coaches said that the tennis team within itself was already united. They didn't have any dissension or anything within the team. And these 3 members were the top 3 players on the team.
Of course there's no problem.
They were the top 3 players on the tennis team, and also they were outstanding students within the school. And even though their hair was long, it was also said that their hair was never untidy, and it always looked neat.
Well, and I think that comes back to the armbands. If there's no problem, there's no issue within the school of, yeah, there's a policy for it, but if it's not causing a disruption or anything throughout the school day or them playing in their sports, then why can't they? I mean, that's the right to express themselves again.
But also, when we was talking about equal protection, can you see why they claimed equal protection? They were the only team within the school that had a grooming policy. Nobody else, and even in general, the school didn't have a grooming policy, but they had an athletic code that had a grooming policy for athletes.
Well, I mean, even now, the Yankees have a grooming policy. You're not allowed to have facial hair if you're a Yankee.
Our high school
Or long.
boys teams like that, he doesn't let them wear braids or anything, they have to be knee cut, low cut.
A lot of that
And
now
we've
comes
had
down to
players
coach.
not play because they didn't want to cut their hair, you know, they were in the dreads and all that stuff there, but, you know, the next year they might come back, but I guess if they challenged it, they probably could, but, you know, I guess they respect him enough that they go along with it. And they have to dress too, shirt and tie when they travel to, you know, uniformity and stuff to do, but I guess if nobody's complaining, I guess they could. I mean, going by this, and I mean, they have a right to, it's not a school policy and it doesn't interfere with anything, but I guess he just wants them to look.
Remember in these cases as we go through, the courts are looking at what is the reason for the rule, number one. What is the reason for the rule? Does the reason make sense? We're going to deprive a student of what the student sees as a right. The Constitution may say is a right. Do we have a good enough reason to deprive of that or not? In this instance, it was uniformity and conformity. That's not the reason.
And this was another case, Carr versus Smith. This was in Texas in 1972. It was a similar incident with long hair. A student was denied enrollment into the school for failing to comply with the school board regulations as far as the hair policy. Prior to being suspended, they had went to him and his parents had went to the school a couple times, had meetings within with the school superintendents or the school personnel about that, but didn't come to any justification or didn't come to any agreement.
This one, they were trying to enroll into school.
Right, yes.
They weren't allowed.
They weren't allowed to enroll. They were trying to enroll in the school, but they refused enrollment because of his hair, because of the hair policy. And so they filed suit and took it to court, and after 4 days of trial, they came back and said that it violated the due process, which was guaranteed by that the rule violated the due process and equal protection guaranteed by federal constitution. And the defendant filed a motion sustained because they filed for an injunction so they could go to school, and the school district filed a motion to stay the injunction. And on a narrow margin between 8 to 7, they found in favor of the school on this one.
So they had cut hair in one of those schools
Yes,
in 1970.
1972. But also, in my research, we're going through this, they found that that the courts were being bombarded with a lot of these cases, and with hair length and stuff like that, and they felt that that should be held either initially at the school district or at lower court, but they shouldn't be brought up towards the Supreme Court to make a ruling on something that should be held down at the school district. One of the things they said, observing the most frequency that's based on the constitutional right of wearing long hair in the First Amendment, the appeal court majority stated for some, no doubt that wearing long hair is intended to convey a distinct meaning, message to the world, but in many, just wearing long hair is simply a matter of personal taste as a result of peer group influence. So by this time they've heard so many of these things, so they just figured that it was, at this point, it was something that should be pushed down and it should be held at the lower level instead of brought up to the courts. And these are some of the cases that they referred back to when dealing with this particular case.
Okay, in John versus the Board of Trustees, on August the 21st of 1975, Mercer was suspended from school for being in violation of their hair length. The same thing as the previous cases. The school had a hair length violation. It means all boys had to have a low haircut. So in this case, it only applied to the boys. Girls didn't have a hair length violation or anything like that. It only applied to the boys. So in this case, Mercer believed that it was in violation of the Texas Constitution, which states, which the Equal Rights Amendment was under, that basically because it was a male and female issue, and because only boys had hair length dress code and girls didn't, it violated the Texas Equal Rights Amendment. So he brought a suit against the Board of Trustees of the North Forest Independent School District. Trial court denied Mercer's application for temporary injunction. So he appealed. And when he appealed, the 14th Court of Civil Appeals affirmed the trial court's decision by refusing to intervene. The trial court basically stated that that should be dealt with in the school system. The jury should not have to decide on whether boys and girls should have a dress code violation as far as hair length. So they basically said that the courts need to stay out of that and the schools need to stay out of that. So both the trial court and the appeals court both refused to intervene in this situation.
And the state has the choice to do that. So it can vary among states.
In this case, 18-year-old Austin was a senior in high school in Colorado City, Texas. Another Texas case, another hair length case. Barber challenged the school's dress code hair regulations, that basically said that boys' hair could not go past the collar or to the bottom of the ear, and boys could not have hair in their face, and boys could not wear earrings. So, because he was 18 years old, he believed that he did not have to abide by those rules because he was of age. So the school stated that the dress code established was to teach grooming, hygiene, instill discipline, prevent disruption, avoid safety hazards, and to teach respect for authority. Barber and his family both believed that any student that was 18 years old of age should not have to have a hair length regulation. So they brought a suit. At trial court, they held that the hair and earrings provision on the grooming code violated the state's Equal Rights Amendment and awarded Barber $13,600 in attorney fees. The school appealed. The Court of Appeals reversed and rendered a take-nothing judgment against Barber. It stated that Barber cause of action did not justify judicial intervention in the school enforcement of the grooming code. Again, this was a case where the courts refused to intervene. They believed that the school and the superintendent in the district should have a say-so on what the school's dress code should be.
So we have a case with the Confederate flag. This was in 2008 in an area, actually this school, their mascot was the Rebels. And they obviously had a Confederate flag along with that mascot. And it had been that way since 1938. So you can imagine the context of the area. So in this school, there had been a fight that was between a Caucasian student and an African American student, and that happened around in February of 2005. This point was real pivotal in the great increase of racial tension in the school. Same year, a couple months later, September, Derek Barr wore a shirt with the Confederate flag on it. Can't really see it there, but some of you may have seen people with Dixie Outfitter shirts. They typically have a Confederate flag and something to encourage support of Southern heritage. And that's the type of shirt that this student wore. Had two dogs on it saying that they were guarding their Southern heritage. The principal ordered that he wear the shirt inside out, and so he did. And around this time, it was very, there were a lot of problems. There was graffiti being written on the bathroom walls with hit lists, with threats, with, very unfortunately, there was a noose with a Confederate flag next to it. And that's important because that's where the ruling for the Confederate flag to be out really was clear. So also the population of the school was 10%, less than 10% African American. Yeah, 1,750 around students. And as a result of these threats, I mean, they got pretty intense. Students didn't come to school. So the principal had to deal with that. And when there were things being written on the walls in the bathroom, they had to take students out, question them, so students were missing class. So this was completely and clearly causing a disruption. So both the plaintiff and the defendant filed for summary judgment. I found out during this case, it was very interesting because normally plaintiffs don't file for a summary judgment. Only the defendants do. And in this one they did. They didn't win, the defendants did. So this is a precedent case because of the material and substantial cause that was in the school. So we have the racially motivated incidents, the tension that it caused among the student body, and the ban wasn't to discriminate against your view about the Confederate flag. It was purely because it was creating a disruption. Well, so to speak. So they were awarded summary judgment. And so in this case, the student audience was highly outweighed in the court's eyes than the student's right to speech. They even said that they considered greater sensitivity to the effect of the student's speech on the student audience. Another interesting court order that happened during this case was the Court of Appeals did what's called de novo, which means that even though the district court evaluated the evidence for summary judgment, they decided to look at
brought to an appeal. It's not only the basis for the appeal. So this is pretty unusual, but they're gonna go back and look at it, just like the trial court would look at it. All that evidence. Go ahead.
And a precedent case that was viewed, that happened in this district, was Melton versus Young, and they upheld the suspension of a student for violating the dress code, and they further banned the display of the Confederate flag, and they ruled that it did not violate the First and 14th Amendment of the students' rights. So they changed their mascot. They're the governor's blue and orange to date.
Okay, I want to say one more thing. You heard her say that either side could file for summary judgment. That's totally against what our textbook says, isn't it?
Yeah.
Okay, so this was just like a mystery, and I didn't understand. Eric asked me why, I didn't know why that was allowed till I started looking online. This occurred in Tennessee, and Tennessee has a law within the state that allows either side to file for a summary judgment and have the burden of proof then to support their case and ask the judge to dismiss or find the claim.
So the plaintiff can file and turn right around.
Plaintiff can file,
And say you got it my way.
yes.
Okay, I'm sure that works off.
Know your street.
And Palmer versus practice. Wakakushi, Wakachachi. Or Independent School District, 2009. On September 21st, 2007, Paul wore a t-shirt that had San Diego on it. The school had a policy that stated that students couldn't wear anything with a written message on it. So he was asked to change his shirt. So he called his mother, and his mother then bought a t-shirt that had John Edwards for president 08. The assistant principal, Johnson, then also told him and the mother, okay, neither shirt is allowed. So Palmer went to the principal, and the principal also denied it. Said he couldn't wear either shirt. So then he went above the principal and went to the superintendent, and he also said that shirt violates the student dress code, that you cannot have any written messages, whether it's something as simple as San Diego. So Palmer and his family have brought a suit. On April 1st, 2008, Palmer sued the district alleging that the dress code violated his freedom of speech under the First Amendment. On May 19th, the district submitted a new dress code. On May 8th, Palmer motioned for a preliminary injunction. So during that time, the school had to submit a new dress code. So on May the 19th, the district submitted a new dress code which restricted speech, including polo shirts with messages, shirts with professional sports team logos, and clothing with university messages. Because basically they said that the first dress code that stated no written messages, they needed to go more in depth. So they submitted a new dress code. So after they submitted that on May 19th, Palmer had went to the principal and bought him 3 new shirts. One of the shirts was still John Edwards for president 08. The principal denied all 3 shirts and said he could not wear them. So he sued again. And he requested a preliminary injunction again, and the district court denied it this time. He appealed, but the district court decision was affirmed, basically saying that because of the new dress code, and it basically states that no messages, shirts with professional teams, and clothing with university messages cannot be worn to school. So, and the Tinker case was a precedent in this case as well. The district court basically said that Palmer had not shown that he would suffer in any type of way if he couldn't wear the John Edwards shirt And because the dress code had basically denied and basically said that he couldn't wear it, they affirmed the lower court's decision.
Okay, now, so that's a little confusing. If Tinker is the basis of this, and Tinker said you can wear the armbands because it's not disruptive. In this case, they're saying you can't wear the shirts.
Well, one of the reasons why they say he couldn't wear the shirts because they allow students to wear buttons, armbands, or anything, something like that, to represent the president who they was voting for or campaign they were supporting. But they couldn't wear the shirts, any type of clothing.
Well, I can see that they could come to that decision. I'm just wondering why it's linked to Tinker or Tinker had a different.
That was one, when I looked online, that was one of the cases that was listed. But that was the one, that's one thing that they brought up in court. They were saying that, okay, you can show your support by a button, just don't put it on the shirt.
Does the school have a policy you could wear a button or have a sticker or something affixed to your book bag, but you couldn't wear a t-shirt? Buttons and stickers,
So this
but no
was likely
t-shirt.
used by the plaintiff, trying to find.
So they're trying to say, well, since they could wear the armband in the Tinker case, that they should be able to wear the T-shirt in this case. What I understand?
Right.
There's no disruption.
So
Yeah,
But that's not what the court is doing.
Right.
Yeah.
It should be a little, but that's,
like I said, the main point that was brought up in court was they had other ways to show their support. They didn't have to violate the school's dress code to show support. They can wear a button, like I said, a sticker. You're still showing your support, but you're not violating the dress code like that.
how can they, well, his first suit was because of the San
It
Diego.
was the same thing because of the T-shirts.
How can the court uphold their policy? I don't see a problem with having a professional sports team logo.
Like I said, the first dress code, it stated there's no written messages. So I guess they couldn't have a shirt with anything written on it.
that's hard.
And because that was too vague,
But you see
they
when you're
made
trying to
them rewrite
avoid.
it.
It's like all
Just
shirts
tees,
now.
tees.
What we're missing is the reason for the policy.
Yeah.
Yeah, that's what I'm saying, like, how could the court have upheld that? What's the reason for,
Right. Maybe if they had a
I think
situation in
the
the
judge
past
has
that
that thing.
caused a disruption or a fight or something.
yeah.
Then it would be justified. Okay, so we kind of touched on this in the beginning as far as what support schools have in enforcing, while enforcing dress codes. Dress codes affect, or the dress, the attire, the grooming, how students carry themselves can affect student behavior and learning. If it's disruptive, you can think of many things. So any disruption to the school learning environment will not be tolerated. That was a quote from a district court case in the past, I think. And this you'll probably see in all of your dress code policies. I'm not going to necessarily read through it, but it does what this school was trying to do with no slogans. They try to cover every angle, so there's no room for violating the dress code or disrupting in the classroom. Okay, when courts review dress code issues, they consider if the student's expression contributes material or substantial cause for disruption, and what case did that, or what was going on? Material and substantial,
The Tinker versus Boys.
and it wasn't found.
Right.
And there was one that was, where they found, okay, this had,
The Confederate flag one.
yes. And they also consider if the student's expression is vulgar or offensive in a sexual way. They also consider if the student's expression is through school-sponsored speech. Now, each of these have precedent cases. However, student dress and grooming also is treated within the terms of freedom of speech. So these precedent cases have to do with freedom of speech. The Tinker versus Des Moines, and that's the our case. So that's going to be the main one. Bethel School District versus Fraser. During a political debate in school, one of the candidates said very sexually explicit things during a video campaign that was aired through the school. And they determined that the speech, determining what students say, can be regulated by the school.
The school was taking away the students' right to speak at graduation or something, I think, as a result of having used that kind of language. And that's why the student was trying to sue. They were taking away that, I think, that privilege, if I remember that one right. And of course, they, as you said, they supported the school board's action on the school's action.
In the Bethel case?
Yeah. That's the one where he was using sexually explicit
Yes.
language? Yeah.
Oh, you're saying they referred to that case?
No, I'm saying that it was because of the actions of the school in taking away a student right that the suit was even filed. Because the student used sexually explicit language, they said, you're not going to speak at graduation.
Right.
Oh,
Oh, okay. So the speech has to agree with fundamental values of public school education. The Hazelwood School District versus Colmeyer case, this was students who were on the school newspaper, were writing things, and the school officials did not allow them to publish what they wanted to write. So they sued. And the school was saying, well, we have the right to overlook and make sure that what they're saying we agree with because we're sponsoring it. So from now on, if the school sponsors the speech, debate team, anything like that where the students are expressing that the school officials have the ultimate authority in regulating their speech.
And that most often applies like to your newspapers and your books.
right.
Okay, some implications. Research indicates that dress and appearance often sets the pattern for classroom behavior. And that's why most schools are going to uniforms, because they feel as though if students can't focus on what the other person is wearing, they can focus more on education. And they feel as though uniforms, they have a more disciplinary behaviors out of students when schools go to uniforms. The dress code is established to teach grooming and hygiene, instead discipline, prevent disruption, avoid safety hazard, and teach respect for authority. The teachers should be familiar with all the policies.
Yeah, teachers, coaches, and administrators should be familiar with the school dress codes and policies. How many, we got anybody here who's already teaching? Are you familiar with your school's dress code and policy? Also, we as students, coaches, and administrators are responsible for properly understanding and enforcing the school's policy when dealing with dress code and appearance throughout the school body. In some cases, I know I had a daughter who just graduated high school, and she would go to school, and I was said, well, I don't think you should be wearing that. That's a little too short. She said, well, ain't nobody gonna say nothing anyway. I said, what do you mean? She said, well, sometimes it depends on who class I'm going to. I don't have this class today. I got this class tomorrow, so she wouldn't wear that because some teachers are forced it, some teachers will let it slide. It depends on what day of the week it is. But as administrators or as teachers and coaches, we need to know what the policy is and always abide by it, because students know who's going to tell them, I don't think you need to be wearing that, or you need to go change. I've seen teachers stop students at the door like, okay, you're not doing that. You need to call somebody, or you're going to ISS. Call somebody, call you, change clothes, or you're going to ISS. But that's part of our responsibility as adhering to the dress code, regardless of what it is. And encourage students to dress appropriately and wear clothing that is not disruptive. That's like Erica was talking about the Confederate jacket and other things that might be considered disruptive. Make sure clothing is not violating the health and safety, the aspect of school operation, and should not interfere with classroom procedures. Again, going with making sure that you're wearing the proper attire, and it's not being destructive or disruptive or causing interference within the class or interfering with other students.
Any blanks still on your paper there? Raise your hand if you have a blank. That's fine. Which one?
A lot.
Let's go through all of them. All right, let's start at the top. The first school dress code rule established by the Supreme Court, also the first case that we discussed tonight. Yes, Tinker versus Des Moines Independent Community School District. Precedent ruling, there must be evidence that school prohibitions, dress codes are necessary to avoid
Materially and substantially.
very good, material and substantial interference with schoolwork or discipline. And ask yourself the question, does it affect others? Does it cause or contribute to a dispute? Could it? In court, students' expression through dress is often addressed within terms of freedom of speech. Freedom of speech. By providing descriptive school dress code and grooming policies, schools can better enforce expectations. Athletic teams have justified grooming codes for reasons of discipline, promotion of closer teamwork, and athletic program uniformity. Is conformity a justifiable reason to enforce?
No.
When you take it to court, no. Male students' hair length was recognized as simply a matter of personal taste in the early 1970s. Some courts refused to use state constitutions to micromanage high schools in regard to grooming cases, believing that the schools must determine and carry out regulations. Extracurricular activities may impose a more stringent dress code because it is school-sponsored. Limits on freedom of speech in public schools. Vulgar speech and lewd conduct is inconsistent with fundamental values of public school. Content of the student speech in what type of thing? School-sponsored activities regulated by school officials. Three main considerations of the courts when evaluating students' dress. Does the attire contribute material or substantial cause to yes, disruption. Does it display blank references? Yes. Sexual, offensive sexual references, indecent or rude words. Fill in as you see fit. You could probably true words. Is a student participating in school-sponsored activities? All right, so we're going to have a couple review questions for you. So these pictures, we can do groups or we can do preference. So number 5.
You.
Which expression is supported under the First Amendment?
Is that baby?
Boobies.
No, boobies. Everybody knows. Some of it looks like babies, some looks like boobies. So it's like,
Do you not have glasses on?
Boobies, that's what it says.
It's for breast.
oh, so B? Yeah, B. I'll go B.
male student was suspended for failure to comply. His grounds for incompliance was that there were females in his class with facial hair, had more facial hair than him. So they want to make the shade.
I would say if this claim was true, then yes.
Under what, on what basis?
Yeah, what basis?
Just unfair treatment or discrimination or equal protection under the law.
Yes.
You got that.
You're definitely gonna get suspended for that facial hair.
Told you you did the shade.
My favorite one.
Oh, number 7.
What was the first woman in dress code case decided by the Supreme Court?
Tinker versus
Yay! Independent Community School District.
In court, true or false? In court, student. 15.
Oh, that's me.
All right. Yes. Students' expression through dress is often addressed to ensure freedom.
Oh,
The school has a day policy on vulgar or obscene slogans on a t-shirt. A student is wearing a t-shirt with a figure that basically resembles a human flames or pulling something over his head with a statement saying, cover me, I'm going in.
Suspension.
Stand that.
You gotta pick a number. This is kind of a general question.
Tell him he's got to turn that into that.
Yeah.
Or she, whoever it is.
Yeah.
Tell that student to go change their gym uniform.
Right quick. Get that out or go. What could you say about this to justify it? Tell them to change.
What can you say?
That's a huge
Sexual and inappropriate reference.
It depends on the dress code, this is a place that covers all that stems about vulgar and
And it's rude.
And if they try to argue with me that it's not, I want them to write me a paper that explains what that shirt's supposed to mean. You tell me, son.
Words.
The ideal of uniforms reached the halls of Congress. President Clinton endorsed the 1990 State of the Union Address.
Number 10.
That's you, Kathy.
What? Oh, I don't know if it reached Congress. Oh, I almost said conference.
Yes.
Good guess.